Good morning and welcome to the Panich Training Academy. It's 9 o'clock and we're just going to give a couple seconds for other people to start rolling in before we begin. You just hang tight with us and we'll get started. Okay. Well, hopefully everybody's been able to join. If not, Crystal will let them in as they join. Welcome to the 40th installment of the Panich Training Academy. Nice round number, 40. Can't believe we've done 40 Panich Training Academies. Today, we will be discussing understanding copyright damages, the legal framework, and some case insights. So, my name is John D. Simmons. I'm an intellectual property litigation attorney, although I counsel many clients also on patent prosecution, trademark prosecution, and copyrights. I was a professional engineer. I'm still a professional engineer in the electrical engineering field for years before becoming a registered patent attorney. So, I focus generally on the tech arts like mechanical and electrical, but I also do a lot of trademark infringement and copyright infringement cases and also theft of trade secrets. My colleagues with me here today are Stephen Lustig and Ava Lutz. Steve is our in-house copyright expert. I go to Steve for my copyright questions all the time, even though I do a lot of copyright litigation. Steve is an all-around copyright expert. And Ava Lutz, who had clerked for federal judges in the past, is our go-to for copyright cases. So she's got all the case law down. So with that, Stephen, would you please introduce yourself, sir?
Yes, hi. My name's Steve Lustig. As John said, I'm the firm's copyright expert, at least for today. One of my former colleagues described copyright law as a minefield for malpractice. So I like to stay on top of it as much as I can. But yeah, all I do is copyright law and trademark law. I do litigate. I dip my toe in the pool every once in a while, but I leave the heavy duty stuff to John and Ava.
Ava, would you be so kind as to introduce yourself?
Of course. Thanks, John. Good morning, everyone. My name is Ava Lutz, and as John said, I'm an associate here at Panich Schwarzy. My practice focuses primarily on different types of intellectual property litigation, including copyright infringement. I also have a background in biochemistry and molecular biology and do some patent prosecution work as well.
Thank you. And generally, two great people to work with, I can say. Okay, so
Likewise.
let me give you some webinar tips. This webinar and all of our other sessions are recorded and can be found on our website to view at any time, which I often send links to new clients to see some of our introductory courses on intellectual property law. If you have any questions, please drop them into the chat in the Q&A section, and we will be checking those areas to answer these questions. If you are seeking CLE credits, as most of us are, for PA, Delaware, Georgia, or Virginia, please ensure to answer the two pop-up polls that come up during the session and take the feedback survey at the end of the presentation. And if we are presenting, will point out that a pop-up has just come up because we all like to get our CLE. Now let's get started with the slides. So what are we going to talk about today? Steve's going to give us just a general introduction to copyrights, explain what copyrights are, how they work, what the act is. We're going to talk about philosophically, why do copyright damages matter? We're going to talk about the types of copyright damages. This one is the one that most people are interested in because they want to know, can I bring a copyright infringement case? Is it worth it? Ava's going to share with us a bunch of landmark cases on copyright infringement damages and explanations thereof. And then we're going to talk about, if we have time, we got a lot of material to cover, practical implications and risk mitigation. And then it's not really a damages concept, but it's more of a litigation strategy concept. It's the concept of preemption. Copyright falls under federal law, so it preempts a lot of state law claims, but it doesn't preempt others. And it goes into litigation strategy as to what claims you bring with what claims of copyright infringement. That being said, let's jump in with an introduction to copyright law infringement from our copyright expert, Steve Lustig. Steve?
Th- Thanks, John. Appreciate all that. So, good morning, everybody. Everything John just said is applicable. Let me just start off this way by saying that I'm going to be kind of setting the table or laying the foundation for what we're going to be talking about. So, I'll be talking about copyright in general, and I always find it's great in these webinars to start from a point of let's do a refresher course for those of you who know these things, or let's just talk about the basics first. I think it's always a good way to start. So, what does copyright law protect? Copyright law protects an original work of authorship fixed in any tangible medium of expression. So that's kind of a mouthful. So let's break it down. It's got to be original, right? It can't be, you can't copy somebody else's work. That would be infringement, but it stands to reason it has to be original. Copyright law it protects the expression, not the ideas. The way I like to describe this is, let's say you have Einstein, and Einstein comes up with his theory of relativity. Well, that's an idea. So that idea is not protectable under copyright law. But if Einstein writes down his idea in a book to explain it to other people, that's the expression. So that's what's it's the expression that is protected by copyright law, not the idea itself, the expression. It has to be fixed in any tangible medium. Now that could be, on a thumb drive for those people who remember those. It could be, in the cloud. It could be on a word processing program or typewritten, whatever, but it has to be fixed. It can't just be in your head. So generally speaking, copyright extends to books, photographs, movies, songs, sculptures, websites, computer programs, any work of authorship. But you get the idea that it's not the idea itself, it's the expression, and it has to be fixed. Next slide, please.
Sorry.
Nope, that's fine. So a lot of people think that, let me back up. With a lot of intellectual property, people come in with some preconceived ideas that are incorrect. And a lot of what we do in these training academies, we educate people to try and get people out of the bad habits. One of the things that people think about trademark and copyright in particular is that you have to do something to get the rights. Okay, like you have to register to get the rights. Not the case in copyright law. Okay, in copyright law, rights vest with the author immediately upon creation. So as I write, when pen lifts from paper, you don't need to register your work to get the rights. However, registration gives important added protection. The most important is that if you were to get into a dispute, a court would not have jurisdiction over your case unless you had a registration. Okay, so you don't have to have a registration to have protectable rights, and that comes into play when you have international disputes. There's an international agreement called the Berne Convention, and basically it says if your rights are protected in the United States, then your copyright rights are protected overseas. Don't need a registration for that. But if you want to get into a tussle in U.S. federal court, you have to have the registration to give the court jurisdiction. Notice is something that we always get questions about. The recommended notice is, it can be either the C with the circle or the copyright or both. The year of publication, year of first publication, and it could be a range. If it's like a website that you've been updating since 2013, you can have 2013 to 2026, and then the name of the rights holder. So that would be Panet Schwarzy in this case. So that's the notice. Whether your work is registered or unregistered, we always recommend putting the notice in a conspicuous place so that people know that you are claiming copyright protection for the work of authorship. Next slide, please. Thanks. So once you have a work of authorship that's protected by copyright, what are the exclusive rights that are protected? Well, the obvious one is the exclusive right to reproduce the protected work. Right. So if you create a sculpture and somebody creates a copy and it's not authorized, that's an infringement. That reproduction is an infringement. You also have the exclusive right as the author to authorize derivative works based on the original. So what is a derivative work? It's any work based on a pre-existing work. So I'm a Star Wars fan. The prequels, right, which I'm not a huge fan of, but it's part of it's part of canon, let's say. The Star Wars prequels are a derivative work of the original Star Wars movie that came out in 1977. Okay. Jaws 2 is a derivative work of the original Jaws. So George Lucas, Peter Benchley, or whoever the rights owner is now, they would have the exclusive right to authorize those derivative works, any work based on a pre-existing work. You also have the exclusive right to distribute copies of your work of authorship. If your work of authorship is adapted into a play or a movie, you have the exclusive right to perform the protected work publicly or authorize other people to do so. And you also have, in the case of visual works, um, the exclusive right to display the protected work publicly. So that's a summary of the exclusive rights you get when you have something that's an original work of authorship that's protected by copyright. Next slide, please. Thanks. So derivative works. I spent a little bit of time on it in the last slide, but I want to spend some extra time on it because it's coming up a lot in case law and it's coming up a lot in the news. So there's a lot of talk about AI and derivative works. So AI can create a photo or AI can create a story, right? Or AI can create a lot of things. So when does what AI has created when does AI and the interaction between AI and human authorship, when does that rise to the level of protected, something that's protected by copyright? Well, the Library of Congress reviewed this a while ago and a few years ago, and they reinforced the fact that an author means a human author. Okay, so a work of authorship has to come from a human author. It excludes non-humans. So if you give prompts to an AI technology platform that are overly simple, let's say you say, okay, write a book, and the AI platform just writes a book and comes up with a subject and comes up with a character and comes up with all these things, and you really didn't do anything, then that doesn't rise to the level of human authorship. So that type of work is not protected by copyright law. However, when you give substantial prompts and you give enough information to AI or to an AI platform to create something that you actually have authored, it's just elaborating on or something, then that does rise to the level of protection. So that's one thing that it's an evolving area of the law, but that's really where the law is right now. Any non-human is not an author. The work that a non-human creates is not protected. Anything that is created by a human with AI assistance, really, that is protected. Next slide, please. So again, because this is topical, I want to get into a little bit of into a little bit of show and tell here. So that is a picture of me. It's a picture of me walking down the street. My wife took that. Okay. So my wife,
it's June, right?
yeah, it's June. Yeah. And that's why I'm wearing my stylish Panet Schwarzy scarf. So my wife is the author of that photograph. That photograph is protected by copyright. My wife is the author. Although I'm the subject of the author of the work of authorship, my wife is the author, and that's a picture of me. So I loaded that picture that my wife took, where my wife's the author. I loaded that into ChatGPT, and I included a prompt, and the prompt was draw this person as an exaggerated character. Could you advance the slide? Could you go to the next slide, please? Right. So this is what ChatGPT came up with. So let's break this down for a second. Okay.
That was college. It was different.
Yeah. No, this was a few months ago, actually, but it was still June. But so let's break this down a little bit. First of all, ChatGPT decided to make my face some weird amalgamation of myself, John Lovitz, and Lou Costello, right? So working further down, in my left hand, obviously I enjoy beer, even though I wasn't enjoying a beer in the original photograph. Then if you go further down, my third hand, which is apparently coming out of my back, is holding a rocket launcher. For some reason, I'm still wearing the stylish Panet Schwarzy scarf, which is nice. I'm glad they kept that. But for some reason, I have some sort of dynamite device strapped around my belt. And if you look carefully, there's a skull keychain there. And I've clearly blown up some sort of financial institution because there's coins and currency floating around. So yes, did AI elaborate on my wife's photograph? Yes. But my wife still is the author of this, of the original photograph. So this would be a derivative work based on something that my wife did. Okay. So this could still be protected under copyright. My wife would still be the author, and this would be considered a derivative work of what my wife did. Okay. I think I've made my point. Next slide, please.
Thank you.
You're welcome. Just trying to keep everybody, it's early in the morning.
It's an exciting subject matter, we know, but it helps to have a little,
Yeah, and
humor.
not everybody the coffee has kicked in. So, just letting it. So, duration of copyright protection. I say works created after January 1st, 1978. That's because the statute changed back then. So now in general, copyright protection lasts for the life of the author and 70 years after the author's death. So that's basically to protect the author's offspring, right, or next of kin. For joint works, you take the life of the last surviving author, if there's more than one author, and then 70 years after that last surviving author's death. Works made for hire. A work made for hire is where an employee, well, there's two things. The most common type is where an employee is working for a corporation or just an employer, and the employee creates a work of authorship within the scope of their employment. Under such circumstances, the employee is not the author. The employer is considered the author because the employee is working within the scope of their employment. So another situation where a work made for hire comes in is where a work is specially commissioned as a work made for hire, and there's a written agreement saying the work is a work made for hire. And there are some other criteria, which I won't get into because it gets into the weeds a little bit too much. But anyway, that's the idea, that either you're an employee working within the scope of your employment or you are specially commissioned to create a work. Then the author is either the employer or the person who commissioned the work, and the duration lasts for 95 years from the year of its first publication or 120 years from the year of creation, whichever expires first. Next slide, please. Thank you. And finally, I want to talk a bit about infringement. I'm not going to get too much into this because that's John and Ava's role in this presentation. Infringement occurs when there's a violation of any of the exclusive rights. So if you don't authorize someone to make recreations, or you don't authorize someone to make a derivative work based on your original work of authorship, that's a violation of any of the some of the exclusive rights. That's infringement. Ownership, again, is shown by registration. So if you go into court and you want to show that you own copyright, you need the registration for that, even though the rights attach automatically. Copying involves two elements, okay? The infringement, two elements. One is shown by access to the work. So if somebody comes up with something just off the top of their head, and it's very similar to your work of authorship, if they didn't have access to your work, then that fails the first prong in this test, right? The infringer has to have access to your work. And then the work that they create has to be substantially similar to your work of authorship. So you need those two things: access to the work and substantial similarity. There's a concept in copyright law called sens faire, meaning things that just have to be there. If you write a story about someone who lives in New York and somebody else writes a story about someone who lives in New York, just the fact that they're both taking place in New York doesn't mean that there's substantial similarity, because the fact that they're both in New York, that's pretty basic. That's sens faire. The substantial similarity comes from really looking and finding out whether the things are very, very similar. And finally, the remedies for infringement, if you successfully prevail in a copyright infringement case, you can get an injunction. You can stop the bad person from doing what they're doing. You can get actual damages and profits, which, as John and Ava will discuss, are very difficult to prove. You can get statutory damages, which is a special type of remedy under this copyright statute, where you can get an award of between $750 and $30,000 per infringed works. Now, I know John is going to talk about that, but that's important. It's not per infringement. If somebody copies your picture 1 billion times, you don't get $750 for every copy. You get $750 or $30,000 for that one work. And that's as the court sees justice. And then you can, there's a question that just popped up. Well, I'll finish up. Then you can also get attorney's fees and costs. So Steve's wife owns the rights to the derivative of her original photograph, but could she register? Yes. She is the author, so she can register.
Okay. Well,
I-
good segue, Steve. Thank you very much.
Sure.
Very informative. All right, so why do copyright damages matter? So we're going to get a little philosophical right after we answer this poll. So poll number 1 is up on the board. So if you're seeking CLE, please answer the poll. Whoops. Sorry about that. Okay, so why do copyright damages matter? So philosophically, or the purpose behind the act, it's the deterrence. Number 1, damages create a financial disincentive for infringement. Without meaningful consequences, copying someone else's work would essentially be free. So that undermines the legal protection of the system. Compensation. Creators and rights holders invest time, money, and effort into producing their works, whether it be an artwork or a book. So when someone else infringes, that rights holder may lose sales, licensing revenue, or market value. So damages look to make the injured party whole again. So it also incentivizes creation. Copyright law is grounded in the idea that society benefits when people create. So books, music, software, art, etc. If creators can't be compensated for their work when it's stolen, it disincentivizes. So it does disincentivizes someone efforts to create or to publish. Licensing markets. Many copyright holders, if not most copyright holders, earn money by licensing their work. Think about music libraries and stock photo albums for photographers. If infringers face no real penalty, they have little reason to seek a license. So damages help preserve the market for legitimate licensing deals. And then, as Steve mentioned, there's a special tool. My favorite tool of the Copyright Act is statutory damages. So this is great because when you have a difficult time proving actual damages, you can just say, I'm going to elect statutory damages. And instead of having to prove that there was but for infringement, you just have to prove that there was infringement and that you get $750 to $30,000 per work. And if it's willful infringement, so if you say send a cease and desist letter and the copyright accused infringer continues to use the work, then you might get up to $150,000. That's in the discretion of the court. So as Steve mentioned, actual damages are very hard to prove. So this actual losses from infringement often occur when it's difficult to quantify. This also allows smaller creators to pursue claims without proving exact financial harm. So you got your YouTube musician is breaking through and somebody steals their work. The cost of a federal litigation, even a copyright litigation, is extraordinarily large, and therefore the statutory damages and attorney's fees gives the smaller creators a chance to get to court. All right, so this whole thing is about copyright damages. Steve gave a nice overview of copyrights in general, and we segued into, in the Copyright Act, there's also a provision for damages, and that's Chapter 5 of 17 USC, the Copyright Act. Actual damages under the Copyright Act are under 17 USC Section 504. So actual damages are for the demonstrable economic harm the copyright owner suffered as a result of the infringement, as opposed to the fixed statutory damages a court can award when there's not proof of specific loss. But as we said, actual damages can be difficult to prove in practice because you must demonstrate that causal link between the infringement and the economic harm. This requires evidence like sales records, licensing history, and market analysis, which can be expensive and complex to prove. So we go to statutory damages. We'll talk about that in a second. So actual damages. So under actual damages, there's several other types of damages that can comprise actual damages. There can be lost profits of the copyright owner. This covers revenue the rights holder would have earned, but for the infringement. For example, I would have sold this book, but for your use of my copyrighted information in your book. So that attributes to the defendant's copying. This challenge is proving the causal link between the infringement and the lost revenue. You could also seek the defendant's profits. We call this disgorgement under 17 USC section 504B. So the plaintiff can recover the infringer's profits that are attributable to the infringement. We call that apportionment. What's attributable to the infringement is apportioning the amount of profits made to the infringing act to the extent they aren't already captured in lost profits. So that's a little nuance there. You can get lost profits. So I can get my lost profits as the copyright holder. But if that profits is not as much as the defendant's profits, I may get my lost profits, but I also may get the difference in their profits, which is the disgorgement. And that could make the copyright holder whole. So lost licensing revenue, you could also seek actual damages of the copyright holder would have licensed the work. Typically, this is a hypothetical license negotiation. This is common when there's an established licensing market for the work. It's kind of akin to the music licenses where you can go to a music book and get a royalty-based license on a collection of music, or you go to the Getty's stock images and download images. It's already licensed, then you get a non-exclusive license fee. You can seek diminution in market value. This is kind of like price erosion. So I have a good example of my client was a pretzel vendor. So they sold pretzels. Anybody in the Philadelphia market probably knows who I'm talking about. And they had a competitor take an advertisement on their website. So it was for a basket of pretzel nuggets, and it was whatever the price was. We'll just make it up and say it's $1. And my client advertised, be a superhero, bring a bucket of pretzel nuggets to the office, $1. Be a hero for $1. So their competitor took that image and put it on their website, and they advertised for 80 cents. So now I got an actual damages case, so I can point to use of the work, and it's for sales of a particular product, and I can actually get quantifiable damages. So that's a good actual damages case. But I might also get price diminution or price erosion. So if I had to reduce my price from $1 to 80 cents, that diminution in value, so I get my lost profits plus I get the diminution in value. So some nuances to damages, actual damages. There can be no double recovery. So I had mentioned that you might be able to get your lost profits plus a portion profits of the defendant's profits if their profits are greater than yours, but you can't double dip. That's the key. There's no double recovery. There are alternatives, not additions. Causation is critical. Courts require the damages be actually caused by the infringement, not just temporally associated with it. And then there's apportionment. This comes out in almost every intellectual property case, actually, but especially in copyright cases. When a defendant's products come from a product or work that incorporates both infringing and non-infringing elements, for example, a film that uses one infringing song, the courts will try to apportion only the profits attributable to the infringement. So that can make a huge difference. So I could go from a profit of $1 million to one song in a film, and it comes down to a profit of a fraction of a percent of that. So actual damages and profits are covered under Section 504B. How do I get my lost profits? So it's the copyright holder's burden to put the gross revenue on the board. So it's gross revenue. Then it's also the copyright holder's burden to prove his or her deductible expenses and the elements of proof attributable, apportionment, to factors other than the copyrighted work. Now, naturally, the copyright holder is going to want to kind of try to keep costs down. So there's a debate what goes into the costs to get deducted for a lost profits analysis. And I want to try to soak as much into fixed costs if I'm the copyright holder. Fixed costs aren't deductible. You have fixed costs like rent, management overhead, various overhead expenses like returns and shipping. You have incremental costs, the cost to make one more widget. So if I have to make this next widget, it's going to cost me more material and cost of goods. It's going to cost me more material and shipping. So those are incremental costs. So the copyright holder's goal is always to reduce the costs and make the profit maximum. On the other hand, When seeking disgorgement, the copyright accused infringer is got a burden on his hands. So it's the copyright holder's burden to paint the gross profits, the gross revenues of the infringer on the board. But for disgorgement, the infringer is required to prove his or her deductible expenses and apportionment of those different expenses. So what happens oftentimes, naturally, the infringer wants to drive costs up. So they're going to want to take costs such as overhead, labor, engineering management, that sort of thing, and try to soak it into the expenses, rent. So when doing a deposition of a damages expert in a copyright case and you're the copyright holder, you're looking at those costs and saying, this cost is not an incremental cost, it's a fixed cost. And you're trying to pull the costs out of that calculation. Okay,
All right.
Ava, I'd like
Yep.
to switch it to you.
All right. Thanks, John. I'm going to talk some more about statutory damages, and we've talked about it quite a bit, so I'm just going to hit on some key points again here. So statutory damages under Section 504C of the Copyright Act are very beneficial, as been said, because you don't have to have proof of actual financial harm. The copyright owner can elect to pursue statutory damages as opposed to compensatory damages of such as like actual damages and infringer's profits, as John was just discussing. So the copyright owner can elect to pursue statutory damages instead of those actual damages. And the Section 504 provides a standard damages range that the copyright holder will receive a damages award for, which is $750 to $30,000 as the court considers just. And if there is willful infringement, that ceiling of the $30,000 can go all the way up to $150,000 for a damages award. And in that case, the burden is on the copyright owner to prove that the infringer knew that it was infringing or that they were acting in reckless disregard or willfully blind to be eligible to potentially get a $150,000 statutory damage award. And on the other hand, if there's innocent infringement, that 750 bottom number for the standard damage range can drop as low as $200 per infringed work. And in that case, instead of the burden being on the copyright owner, it's on the infringer, and they have to prove that they had no awareness and no reason to believe what they were doing was wrong and infringing. And another point on the willful infringement, that emphasizes the importance of, or demonstrates the importance of sending a cease and desist notice early on, or letter, because it puts the infringer on notice, and then as the plaintiff, that will help make it easier to prove willful infringement, and that they were aware that what they were doing was wrong. And then there is the crucial registration prerequisite that's been discussed already, and that statutory damages are available only if the work was registered before infringement began or within 3 months of first publication. So registering your work early on is very important because you could potentially miss out and statutory damages could be off the table.
Yeah, and
Okay.
Steve can tell you, registering a copyright is relatively inexpensive compared to other intellectual property. Like patents are very expensive, trademarks are incrementally expensive, but copyright registration is relatively cheap. And oftentimes we teach clients how to file copyright registrations themselves. So, for example, I had a video game client and they got knocked off a lot and they filed their own copyright registrations, which makes it so that they can flag us and say, hey, somebody's infringing our copyright. And now we can go after them for statutory damages and attorney's fees. Sorry, Ava, didn't mean to interrupt you.
No, please. And then just here's the statutory language for statutory damages. Just two things I want to point out, which are the two highlights here. The first, with respect to any one work, with respect to any one work. And this means that statutory damages are calculated per work infringed, not per act of infringement. So if a defendant makes 1,000 unauthorized copies of a single photograph, that's still just one statutory damages award. The number of awards is determined by the number of distinct works that were infringed, not how many times each work was copied. And the second part of the statute I want to point out here is the last sentence. For the purpose of this subsection, all the parts of a compilation or derivative work constitute one work. And this is important because, say the work is a compilation, the whole thing counts as one work for damages purposes. So if you publish a photography book with 50 photos, a court might treat that as one work rather than 50, and that can make a very significant difference in the amount of damages you could recover if you do opt to pursue statutory damages as opposed to compensatory damages.
There's a philosophical note there. So if you file a compilation, let's, for example, we have a client who files all the pages of their website, and their website is actually an operable website. So it's software as a service. So it's driving income by use of the website, its service, right? And they file the compilation. Their competitor copies their entire website. They only get one work. They don't get every page. So it might be that you want to file separate trade or copyright registrations for each critical page and then file a compilation for the entire website. But that's a business decision. And you don't know, it'll be years. You file the copyright registration 1 year, and it could be 3, 4, 5 years before you actually enforce the copyright. And the reason you filed the copyright in the past just doesn't seem to matter by the time you actually get to court.
And this slide, it's really just reiterating the difference between the willful versus innocent infringement and how that can increase the statutory damages range from the 30,000 to potentially 150,000 if there's willful infringement, and it can also drop it down to the award from $750 to as little as $200 per work infringed if there is innocent infringement.
Yeah, and just as an aside, remember that range of up to $150,000 is in the discretion of the court. I got a good example. The largest jury verdict ever for a statutory damages case was Sony Music versus Cox Communications. It's a 2019 case out of Virginia. And the jury awarded the record companies and music publishers $1 billion in damages against Cox Communications for failing to prevent repeated infringement by its customers. The jury found Cox had committed willful, contributory, and vicarious copyright infringement of over 10,000 works, but they only awarded $100,000 per work. So you can see Cox did a lot of bad acts, but yet they didn't get the full $150,000. So going into it, the $150,000 award's not a slam dunk, but it's a great threat. Okay.
That's it. Back to you, John. Yep.
Other remedies. So injunctions, Steve mentioned this at the outset. Almost always you seek a preliminary or permanent injunction in a copyright case. And if you have a good case for infringement, if they find for infringement, you almost always get a permanent injunction in a copyright case. Attorney's fees. This is my favorite. So a reasonable attorney's fees may be awarded to the prevailing party in the court's discretion. There's no presumption for or against attorney's fees. The court must exercise equitable judgment. But if you have a registration before the infringement and you prevail on infringement, you can almost guarantee attorney's fees. So one of my favorite things to say to opposing counsel when we start negotiations is, you're paying me to sue you. Other remedies, impounding and disposition of infringing articles. This is a subject unto itself. There's various provisions in the Copyright Act and various acts that were appended to it, such as the Digital Millennium Copyright Act, the DMCA, which you can go on to digital services like Amazon or Etsy or Shopify and do a takedown notice and get the electronic copyright accused goods taken down. But you can also, if you get a judgment, go to customs and have containers seized at the border. So copyright is very strong if you have a good case. All right, Ava, you're going to talk about some landmark cases.
I am.
Before Ava starts, can I just say one thing about customs?
Oh, sure, please
Since
do.
you brought it up.
Yep.
Yeah. One thing about customs that people that people often forget or people don't realize is that for customs to act, you have to have the registration, but you also have to record the registration with Customs and Border Protection.
Mm,
So
good.
again, one of the big bullet points of this presentation is register, register, register. But yeah, customs won't automatically start enforcing your copyright at the border. You have to register first, and that creates the nexus. So just wanted to add.
Very good tip, Steve. Thank you so much.
All right. So some landmark cases on the different types of damages we just discussed. John, if you could please go to the next slide. All right. First, starting with compensatory damages cases. First case is Sheldon v. Metro-Goldwyn, and this is a foundational Supreme Court case from way back in 1940. And this case is the holding of this case was that apportionment of profits is permissible. And as the court said, the purpose is to provide just compensation for the wrong and not to impose a penalty. In this case, the Metro-Goldwyn produced a film that infringed plaintiff's play, and the film was a big commercial success, and the plaintiff argued they were entitled to all of the film's net profits, but the profits came from many sources beyond just the play that the film was based on, such as the actors and the fame of the actors, the scenery of the film, and directors, all the different factors. So the court did find that apportionment of profits is permissible, and the Sheldon v. Metro-Goldwyn case established a two-part test for apportionment. The infringer has the burden here for apportionment, as John said, and the infringer must show first that not all profits are due to the use of the infringing material, and second, that the evidence is sufficient to provide a fair basis for separating infringing from non-infringing profits. Next slide, please.
Oops. Went too far. Sorry. Go
That
ahead.
one, yeah.
On Davis versus the Gap.
All right, so staying on compensatory damages, but now looking at actual damages. On Davis v. The Gap, it's Second Circuit case. In this case, The Gap, which is the retail clothing store, used Davis's protective eyewear or protected eyewear design in a national ad campaign without authorization, of course. It was pretty clear-cut infringement, but Davis had a damages problem. He did not register his copyright in time, so statutory damages were off the table. And once again, just to reiterate the importance of registering your copyright early, so you do have statutory damages at your disposal if that is the better alternative. He also could not point to any licensing deals he missed out on because of the Gap's infringement. And when he tried to recover a share of the Gap's profits, he could only point to a 1.6 billion revenue amount for the parent company of Gap. And the court said that's way too far attenuated to tie back to the profits derived from the specific infringing ad that used your protected eyewear design. So all that being said, he basically had no damages theory except for the fair market value of a hypothetical license for the infringing use of his protected eyewear design. And the court did hold that actual damages under Section 504B may be measured by the fair market value of a hypothetical license. And the reasoning here was the infringer did take something valuable without paying for it, and the copyright owner should be compensated for what that use was worth. And the hypothetical license, the fair market value, is not what the owner would have demanded. Instead, the question is what a willing buyer and willing seller would have agreed upon. Next slide, please. All right, two cases I'm going to just touch on that deal with statutory damages. The first is F.W. Woolworth v. Contemporary Arts. And this case really established that statutory damages serve a dual purpose, to compensate and also to deter. And the court made clear in this case that even where the infringement caused no provable injury and generated no profit for the infringer, the court can still impose liability and award damages amount. And then the second case here, Feltner v. Columbia Pictures. This case held, or the court in this case held that the Seventh Amendment guarantees the right to a jury trial on all issues pertinent to an award of statutory damages, including the amount. And at the bottom of the slide, I just have some factors courts consider when assessing statutory damages. And as John and I both touched on earlier, I believe we all have, that statutory damages are truly a matter of discretion. And the court can, find anywhere within that range of $750 to $30,000 that they deem just. But here are some factors that they do consider. Next slide, please. And it looks
Time for the
like
next poll.
perfect timing. Yeah, the next poll is up for CLE credit. So make sure you answer that if you need CLE credit. And then,
Sorry about that, Ava. I think I went back a slide.
yes, just one more forward.
Yep, there you go.
Okay, so now we're switching gears a little bit to talk about statute of limitations, but obviously statute of limitations is relevant to damages because if you miss out on your time to file a copyright infringement claim, you won't be able to recover all the damages that we've been discussing. John, I think you just went back one slide, if you could go.
Sorry about that.
Oh,
Yep, there
no
you go.
worries. So Section 507 of the Copyright Act covers the statute of limitations. It reads, "No civil action shall be maintained under the provisions of this title unless it is commenced within 3 years after the claim accrued." So what does that mean? 3 years after the claim accrued. A copyright claim, so there's two different rules that courts have adopted to determine what that means by the claim accrued. One here is on the slide, which is a copyright claim accrues when an infringing act occurs, and that's what triggers the 3-year limitations period. The other rule, which I intended to put on the slide but left off, is the discovery rule, and that is the copyright claim accrues when the copyright owner should have or did learn of and discover the infringing act. And another thing to note with statute of limitations is the separate accrual rule, which is a new statute of limitations period begins to run with each separate instance of infringement. And the first case I'll discuss here briefly dealing with statute of limitations is Petrella v. MGM, which is 2014 Supreme Court case. And the holding here is pretty straightforward, which is laches, the equitable defense, cannot bar a damages claim brought within cannot bar damages if you bring a copyright infringement claim within the 3-year limitations period. So it makes to me logical sense that if you are within the statute of limitations, and even if you did wait a bit to bring a claim, you're not going to be barred from bringing it because of the laches equitable defense. And then the next case for statute of limitations is Warner Chappell Music v. Neely. So in this case, Neely filed suit in 2018 for infringement, stretching back the infringement went all the way back to 2008. And he discovered the infringement in 2016, making his claims timely under the discovery rule. Because if he discovered the infringement in 2016 and filed suit in 2018, that's within a 3-year period because the clock started ticking when he learned of the infringement in 2016. Where it got more interesting, though, is he able to claim the damages that went all the way back 10 years, the infringement that started back in 2008, even though, So can he get those damages dating all the way back to 2008? And the court said yes. The 3-year limitations period only controls when you have to file your lawsuit. Once your claim is considered timely, there's no separate cap on how far back your damages can go. So Neely could potentially recover the full 10 years of infringement or damages for that full 10 years of infringement. Next slide. All right, so I'll just cover two cases that discuss the attorney's fees. First is Fogarty v. Fantasy, which is a Supreme Court case from 1994. And this case really established that the plaintiff and defendant are on equal ground when it comes to recovering attorney's fees. The prevailing party, so basically the prevailing party could recover attorney's fees, and it's a matter of the court's discretion. And on the slide are some factors that the courts consider when determining if attorney's fees are appropriate. There's frivolousness of the claim, motivation, and then the next case here is what established the next factor for determining if attorney's fees are appropriate, which is the objective unreasonableness of the losing party's position. So the Kurtzsang v. John Wiley Supreme Court case from 2016, that case held that substantial weight should be given to the objective reasonableness of the losing party's position. And this is a factor that, of course, goes into the calculus to determine if attorney's fees are appropriate, but it's not dispositive. So even if the losing party's position is very much unreasonable, a court may not award attorney's fees. And in reverse, even if the position is reasonable, a court in its discretion could still award attorney's fees. And I think that's all of the landmark cases.
Thank you, Ava. That was great. All right, so we're a little tight on time, so we'll try to pick up on the back end here. So how do you protect your work? So most business models for copyrights are for licensing or contracts. So music publishers or record labels routinely license their songs for streaming, sync, radio, and they often offer collective licensing organizations like ASCAP or BMI or CSAC, where you can get a license for a whole collection of works. Similarly, stock photo agencies such as Getty, Shutterstock, or Amalme exist entirely to license images of photographers. These stock photo people are kind of annoying. They typically have small firms that police for the use of their images. So they have scrapers that go across the internet, and then they send letters that were written by paralegals to potential infringers who may have inadvertently put a picture on their website that was from a Getty's stock image, and they try to stick you up for willful infringement. So be very cautious when putting photos on your website. You can also have software licenses. So software as a service we mentioned earlier, that's typical licensing model for software these days because everything's in the cloud. Steve mentioned the thumb drive, if you ever heard of one of those. I actually have one in my hand right now, but everything's in the cloud these days. So we know software as a service is a license. So people just basically rent the use of the software. Copyright registration benefits. I think all three of us have really driven home that register and register often. The reason why I try to get my clients to get trained on how to file their own copyrights is because the filing fee is only something incremental, like $30 or $50. And if you're taught how to fill out the form correctly, it could be very beneficial to have a collection of copyrights.
Sorry to interrupt. The filing fee is actually 65.
65. I'm sorry, it went up. I'm getting
No,
old.
no.
I'm getting old, Steve.
No, that's what I'm here for. But also, if you have to urgently register your copyright, it's a lot more than that. It's 65 plus 800.
Another reason to register up front, right? So as soon as you're about to publish your work, you should file for registration of the copyright. That's very important. I have people come to me, and Steve and Ava have the same experience because we work on cases together. Happens all the time. We get this copyright infringer, and it's blatant copyright infringement. Like it's the exact photograph that was on my website. They're selling knockoff sneakers on their website using the same exact copyright design. And yeah, when did you register your copyright? I didn't. Now we have to file an expedited copyright registration, which costs how much, Steve? It's over $1,000.
Well, I mean, there's our fee. There's whatever the attorney's fee. Let's say
Yeah, what's the
hypothetically the fee
filing
is
fee?
$600, but the official fees are $800 plus the 65 regular. So $800 to expedite.
And then attorney's fees. So that adds
Right.
up
Yeah.
to
Yeah.
a couple $1,000s. And then we have to wait for the registration, which is painful because if you have a copyright infringer out there, that dirty, rotten infringer, you want to bring them to court. But you're waiting for your registration to come, and the government shutdown taught us a lesson. The Copyright
Yeah.
Office doesn't process copyrights applications when the government is shut down. And so that jammed up the system big time. But another benefit to registration, which register, is enhanced damages. You can get statutory damages. There's evidentiary presumptions. Um, if registration is within 5 years of publication, it creates a legal presumption that the copyright is valid and that the facts stated in the registration certificate are true. Although this seldom comes up in litigation, if at all. I provide you with the benefit to do customs recordation. I'm killing time here, sorry. And it is the core takeaway is it's the most critical reason to register, especially promptly, is the availability of statutory damages and attorney's fees. All right. Considering the time here, we're just going to jump to preemption real quick. And Ava's going to help me with this one. So this is not really a damages concept. Preemption is more of a litigation filing strategy concept. And so you have to know that the US Constitution gives Congress the power to create copyright law. So it's federal law. And therefore the supremacy laws kicks in. So federal copyright laws in particular preempt state laws that try to protect the same rights. So think of it as the federal government already has set the rules for the game, so states can't come in and override the constitutionally granted right of copyright. So there's a two-part test. So under Section 301 of the Copyright Act, a state law claim is preempted if the work falls within the scope of the type of works copyright protects. So original works of authorship, as Steve outlined, and the state law being claimed is equivalent to the one of the exclusive rights of the copyright protects: reproduction, distribution, display, performance, etc. If both conditions are met, the state law claim is wiped out, and the plaintiff can only proceed under the copyright law. So it's common that it's a motion to dismiss at the beginning of a case. Give you an example. Say someone copies your novel and sells it. You can sue them under a state law theory of unfair competition or misappropriation if your claim is really just that they copied your work. So the copyright preempts the state law unfair competition or state law on misappropriation claims. And we provided a little lookup table. So there's some state law claims that are not preempted, like breach of contract, fraud, which you have to plead with particularity, moral rights, rights of publicity, and trade secrets. Why this matters? It's a lot to do with litigation strategy. Defendants are often argue preemption to knock out state law claims and force plaintiffs to only litigate on copyright grounds, which may be harder to win or offer different remedies. And it's now at the end of our time, and we're looking to the crowd for any questions. Again, I'm John D. Simmons of Panet, Schwarzy, Bellicero, and Adel. With me, my colleagues Stephen Lustig and Ava Lutz. And we thank you very much for taking your time to join us for the 40th session of the Panet Training Academy. If you see our contact information up there, some of it looks a little jumbled, but you can go to our website, panetslaw.com, and you can find any of our contact information on the Panetslaw website under team. You can also find the video recording of this under the knowledge base and Panet's Training Academy. We look forward to future Panet's Training Academies, and thank you very much for your time. It is now 10 a.m. Have a great day, and thank you for attending.
Thank you, everyone.